Hi, everyone. Thank you for joining us today. My name is Jen Massey. I'm the Pro Bono Director at Children's Law Center, and you're joining us for part one of our Caregiver Custody Pro Bono training. I'm going to talk to you just briefly about our Pro Bono program, our virtual training series, a little bit about today's training in particular, and then also where you can find on-demand resources to support your work with us. If you're new to Children's Law Center, we fight so every child in DC can grow up with a loving family, good health, and a quality education. We help over 5,000 children and families each year, and we couldn't do it without the assistance of hundreds of pro bono partners. We place pro bono cases in those three areas of family, health, and education. We're here today to talk about some of our family law work, specifically caregiver custody cases. These are instances where third-party caregivers, often relatives and grandparents, are caring for children who are at risk of entering the foster care system. These caregivers are looking to provide stable and loving homes for these children, and lawyers make a big difference here, being able to help these family members walk through the legal process and ultimately gain a custody order that allows them to provide continuous and loving care for these children. We support our pro bono attorneys in many ways. We screen our cases on the front end. We provide trainings like these, as well as many resources and materials on our website. And when you take a case with us, you'll get a mentor. It'll be a CLC attorney who's experienced in the practice area for the case that you're taking. They will be available throughout the duration of the case to talk through strategy, as well as questions that you might have about the law and practice. Turning to our virtual training series, so you're here for our caregiver custody work. We are holding virtual training series, virtual trainings in all of the other matters that I just referenced, in family, health, and education. They will be made available on demand on our website if you're not signing up for the dates in July to do them live with us. I've highlighted on this slide one of our trainings for cultural humility. This training is going to be made available on demand as well if you can't join us on the July 23rd date. I encourage you to join this training and watch it on demand if you can. This supports all of the practice areas that we're handling. When working with families, it's important that we understand their realities and circumstances, check our assumptions and biases, and do our best to approach the work in a culturally humble way so that we can achieve successful client outcomes. Today's training, just a few logistics. So it's part one of two for caregiver custody matters, and we're going to focus in on the law and practice today. So you're going to hear from one of our colleagues, talk about the applicable legal standards in custody matters in DC Superior Court, and also what the practice looks like from filing a case and moving through the steps to closure. I have a note here about remote representation. So during this time, we've been tracking the court's operations since the pandemic started. We've also been working with our clients and staying in close touch about their circumstances and needs during this time. And we've been doing this work remotely. So both the client representation and advocacy, our court hearing participation remotely. And these are things that we can talk about through mentoring to support you and guide you and how things might be different during the pandemic. If you have questions today, feel free to use the chat feature on Zoom. You can also email me and we will address what we can during the training and we'll follow up after as needed. About those on-demand resources, we have a lot on our website. So you can find training presentations like today's materials, videos, so this will be made on demand very soon, as well as our training manuals. These manuals have lots of information. So we have that table of contents that we emailed out in advance of the training and have the manual available on our website. Switching to a picture of our website page where you can find these items, you go to childrenslawcenter.org, you'll see at the bottom, which has been circled with arrows pointing it out here, a link for pro bono. When you go to that page, you're going to see on the right-hand side links to these different materials and resources to support your work. Finally, if you are interested in the case, we have various caregivers who are looking for lawyers to help them right now. We could use your help. If you've got questions, please feel free and don't hesitate to reach out. You can email me at the email on the screen, jmassey@childrenslawcenter.org, and ultimately we can chat through whatever case might be a good fit for you and certainly for the client. I will turn it over now to Lauren Berzon-Harriman, who is a senior attorney at Children's Law Center. She mentors on these matters for caregiver custody, and she's going to talk and just walk you through custody law and practice as part one of our caregiver custody training. Thank you so much again for joining us.
Hi everyone, give me 1 minute just to get my screen up for you. Okay, as Jen said, thank you so much for joining us today. We're really excited that you're here. This is part 1 of 2 trainings related to representing caregivers in custody cases. And the material that we're going to cover today is really important no matter what role you're playing in a custody case, but the clients in our cases are almost always grandparents, aunts, uncles, adult siblings of a child, friends, other neighbors, other types of kin. And so we're really going to be talking about representing those folks, those third parties or non-parents in custody cases. At CLC, this is really our focus within our pro bono program, is doing this work. And our goal is to prevent children who might otherwise enter the foster care system from being part of that system. So it's really important work, really meaningful work, and we're glad that you're here to take part with us. As Jen said, we have a manual available on our website. This is just highlighting some of the materials that you'll find on this, in the manual that are relevant to the contents that we're going to talk about today. And I'm going to give you a quick roadmap of what we're going to talk about, where we're going. Give me just a second. Excuse me, everyone. So today we're going to talk about a number of things, including all of those agenda items on our roadmap. However, this is usually a live training where we have more time than an hour to cover all this material. So it's going to be a high-level overview. We are going to go through some of this rather quickly, and we're going to really focus, oh, excuse me. We're going to really focus, give me just a moment. Sorry guys, some technical difficulties here. Okay, we're going to really focus today on developments that are related to COVID-19 and changes that might be different and might be really helpful in navigating through custody cases at this particular moment in time. So you're going to see that any updates related to COVID-19 are annotated in red. I will also say, again, we're used to doing this training live. We welcome questions throughout. Please feel free to put something in the chat if you do have a question so that we can try and address it. If we can't address it, we're happy to connect with you after. And as Jen said, when you take a case from Children's Law Center, you're assigned a mentor who works with you on that matter and is available for case-specific strategy, consultation, whatever it is that you need. These cases are very, very fact-specific and fact-intensive. And so you'll hear me a lot today say, here's a basic overview, call your mentor if you have questions, and we really mean it. Please feel free to call your mentor. Okay, well, just a minute. Forgive me, we practiced this and yet. Okay, so as I said, ordinarily when we have more time for this training, we would spend some time talking about jurisdiction or the question of whether DC is the right place to hear the custody case. Know that if you're taking a case from CLC, it's something that we would have screened for in our intake process. So there's a good chance that that DC has jurisdiction to hear the case. That said, these are jurisdiction, as with these cases in general, is a fact-intensive inquiry, and sometimes those facts don't come out until later in the case. So certainly if you spot something that might lead you to think that DC might not be the right jurisdiction, or if jurisdiction is challenged in the case that you're handling, please call your mentor and we're happy to talk with you about it more. Okay, so now we're going to turn to custody and kind of the meat of custody and what the law is. Custody is not one, oh my goodness, sorry guys. Let me back up here. Okay, custody is not one singular right, it's really a bundle of rights that we're talking about when we're talking about a custody case. So it includes both things that we call physical custody. So that refers to where the child is when with whom. So the child's living arrangements, the child's visitation schedule, residency, things like that. Custody also includes things under the umbrella of legal custody, so the right to make decisions regarding a child's health, education, and general welfare, things that would kind of have a long-term impact on their trajectory, and also the right to access information about that child. In a custody case, the court's job is to allocate those rights between the various parties. So breaking down those different pieces of the bundle and assembling them however is in the child's best interests. It's worth noting that even in third-party custody cases, there are rights that parents will always retain. So for example, a parent will always retain the right to consent to their own child's adoption, even if a third party is awarded custody. Parents also generally retain rights to visitation with the child, and what that visitation looks like, again, is a case-specific determination, but it's something to be aware of and to counsel your client about, that the parent likely will have some visitation rights. It's also important to note that custody is always modifiable until a child reaches the age of majority, which in the District of Columbia is 18. So even when we say that something is final or permanent, and you see an order with that language in it, what that means is that there is nothing pending before the court at this time, but it does not mean that custody could not be revisited as long as the child is still in fact a child. So when the court is allocating those rights that we talked about, the court can grant sole physical custody to one party, or can grant sole legal custody to one party. The court can grant joint physical or legal custody to two or more parties, in fact, or any other arrangement that it determines is in the child's best interest. So what that means is that there's room for a lot of really creative lawyering and advocacy in these cases. You really can get into the weeds with your client and figure out where it's advantageous for your client to ask for specificity, where you might want something to be more broad or more vague. There's really a lot of room to for you as an advocate and for the court to craft an arrangement that will be really sustainable and practical for the family and will really promote the child's best interests. So we're going to turn now to third-party custody. And third-party custody is governed by a separate code section in DC. So we have one part of the code that governs custody actions between parents, and another part that governs custody actions between parents and a third party. We're going to focus on that third-party custody statute today and talk about all of the things that are on this slide. So standing, meaning whether a third party has the right to file, is really a threshold question in these cases. It's the first of three tests that a caregiver has to meet in order to get in custody of a child who is not their biological child. A third party can have standing, sorry, I think we skipped one, sorry. A third party can have standing on three different grounds. So because they have the consent of a parent who has been the primary caretaker for the child during the past 3 years, or because the third party lived in the same household as the child for 4 of the past 6 months and has assumed primary caregiving responsibilities for the child, or because there are exceptional circumstances and the third party is living with the child and those exceptional circumstances warrant some sort of relief. So you'll notice that if you look closely at the statute, there are a lot of things that are vague, that are not defined. There is no explanation of some of this in the definition section. So we don't know what it means for a parent to have been a primary caretaker for a child during the past 3 years. We don't know what it means for somebody to have lived in the same household as a child for 4 of the past 6 months. And there's a couple of takeaways, I think, from all of these ambiguities. One is that there, again, is room for creative advocacy and for really good lawyering on behalf of your client to do, within reasonable interpretation of the law, whatever you think is going to advance their interests. Another is that it's best practice to proceed on as many grounds that are applicable as possible, because we don't know how a court is going to interpret these. There's very little appellate law on these issues. So really, if you can plead standing under more than one part of the statute, I'd encourage you to do so. Again, we will have screened for standing in our intake process, but that doesn't mean that facts that come to light won't elicit a challenge, or that there might be some sort of question. So it's definitely something you should discuss with your mentor if it comes up on your case. You'll notice that on the last slide, if I go back for a second, there was a big "or" on the bottom of the page. And the reason for that is there is a fourth way in which a person who is not a biological parent might have standing to file for custody of the child, and that is if they qualify as a de facto parent. I'm not going to spend time on de facto parenthood today because it is pretty rare and is very specific, but do please reach out to Children's Law Center if you spot that your client or that somebody else involved with the case might constitute a de facto parent, because it does change the applicable legal standards. Speaking of legal standards, like I said, standing is a threshold matter for third-party custody, and then you have to get past two other hurdles. So one is that there is a presumption in favor of custody with a biological parent. So this parental presumption has constitutional underpinnings. A parent has a fundamental right to the care, custody, and control of their child. So when a third party is seeking custody of that child, it's not like comparing apples to apples. The court has to presume that it is in the child's best interest to be in the custody of the parent, and the burden is on the third party, the burden is on the third party to overcome that presumption by clear and convincing evidence. When they've done that, and only when they've done that, should the court assess whether it is in the child's best interest to grant custody to the third party, and the burden of proof is again on the third party to show that by a preponderance of the evidence that it's in the child's best interest. And we're going to talk a little bit more about how to do those two things in the next couple of slides. Okay, so in order to overcome the parental presumption, the statute sets out 3 grounds that and says that one or more of the following have to be met by clear and convincing evidence. So the third party either has to demonstrate that the parents have abandoned the child or are unable to care for the child, that custody with a parent is detrimental to the emotional or physical well-being of the child, or there's that exceptional circumstances language again, that those exceptional circumstances, which must be detailed in writing by the court, support rebuttal of the presumption. Again, a lot of things are not defined here. So abandonment is defined in other parts of the DC code, but not in the parts addressing custody. We just don't know what that means in this part of the statute. So it's a best practice to plead as many as you can and argue as many as you can if you get to trial. So a good example of this would be if you have a case where you think a parent has probably abandoned the child, right? They've been absent from that child's life for years. They haven't come around, they haven't sent support, the child doesn't have a relationship with them. You're probably also going to be able to argue that granting custody to that parent would be somehow detrimental to the child's emotional or physical well-being. So that's the kind of advocacy that I would think through as you're pleading your case and advocating for your client. When the court is making findings about the parental presumption, they are required to do so in writing, to say why they have found that the parental presumption has been overcome by clear and convincing evidence. And then the court is going to think about the best interest factors. So the third-party custody statute lays out 4 non-exhaustive factors that the court should consider when determining whether custody with a third party is in a child's best interest. And I will say that these are not exhaustive, and they're actually different from the factors that the court is directed to consider in cases between 2 parents. In those cases, there are 17 non-exhaustive factors that the court has to look at. So it is important to know which statute you're working in and to be aware of both, because one may help you inform the other. But the factors at play in these cases include the child's need for continuity of care and caretakers, for timely integration into a stable home, the physical and mental and emotional well-being of everybody involved, particularly with a focus on how that impacts the child's well-being, the quality of the relationships the child has with those involved, and then to the extent that it's feasible, the child's opinion of his or her own best interest in the matter. And that last one is really where we start getting into the child's wishes. And we'll talk more tomorrow about how you go about proving that to the court or introducing that evidence to the court. These, like I said, these are not exhaustive, and they're not necessarily in order of importance, so it's important to focus on all of them. I've also been talking a lot about what the caregiver has to do, kind of presuming that the parent is not in agreement with the third party having custody. And the statute actually says that if a parent is in agreement with a third party having custody, then the court must award custody pursuant to that agreement, unless there is clear and convincing evidence that it is not in the best interest of the child. And the timing of that, if a parent is consenting, they can file their consent at the same time as the complaint. They can submit it later. Sometimes consent is given orally at a hearing. It doesn't really matter where it comes in. Anecdotally, again, in this era of the pandemic, we are hearing from judges that they are trying to prioritize cases where there is consent and try and get those to closure as soon as possible. But they may still want a hearing in order to hear from the parties and make sure they are all in fact on the same page. And there may be other delays. So certainly if you have a case where you've got consenting parties and you're experiencing some delay, please contact your mentor and we're happy to strategize with you about that. And of course, consent seemed pretty clear on our last slide, but it is not actually quite as clear as I would have you believe. There are two ways in which a parent can consent in these cases, and they have very disparate impacts on the trajectory of the case. So this is a really important note and a really important thing to think about as you're preparing your negotiations and counseling your client. So the first way that a parent can consent to custody with a third party is by giving revocable consent. And what that means is that the parent retains the right to revoke their consent at any time by filing a notice of revocation with the court. And the statute says that upon revocation, the prior custody order shall be void. The way that we've seen the court treat this is they treat it as though the third party complaint is still pending, but the statutory standards still apply. So the burden would still be on the third party to overcome that parental presumption by clear and convincing evidence and to demonstrate that it is in the child's best interest for the third party to be awarded custody. The other way a parent can consent is by providing non-revocable consent, sometimes also called irrevocable consent. And what that means is that the parent is waiving the application of the parental presumption in future proceedings and acknowledging that a modification could only happen if the parties are all in agreement or if the parent can show that there has been a substantial and material change in circumstances and that modification is in the child's best interest. So it places the burden on the parent at the time of modification. And the Court of Appeals has said that in order for any consent to be considered non-revocable consent, that consent must be knowing and intelligent, meaning really that the parent understands what rights they're entitled to and what rights they are giving up in providing non-revocable consent. Now, I have had people say, well, why would a client ever take revocable consent if it can be withdrawn at any given moment? Isn't that pretty risky? And the answer is yes, it is pretty risky, but it is really a client's decision after client counseling whether to accept consent, because there's more at play than just the legal standards in these cases, right? So a good example is I have a client who at the outset when we talked about this was very certain that she would only accept non-revocable consent from the parents in the case. And then as it went on, and it became clear that the parents were only going to provide revocable consent and our other option was to go to a trial on this, she started thinking that maybe going to trial and creating that level of acrimony and tension within her family was actually going to be more destabilizing than having this court order that would be subject to revocation. And so it's an ongoing conversation that we're having in our attorney-client relationship to kind of talk through what the pros and cons are so that she can make that determination of what is going to be the best situation for herself and for her grandchild of whom she's seeking custody. Okay, so we're going to turn now to procedure. We kind of covered the law part. We're going to shift to procedure, and this is where many of the COVID changes have happened. And I want to note, we're going to start talking about how you file a case, but a lot of clients may come to you having already filed the initial pleading in their case. Some clients prefer to wait until they have a lawyer to file, but not everybody. So if you are retained by a client who has already filed something, you definitely want to be aware of the procedural posture of the case and be thinking about whether you need to file a request for leave to modify the complaint or to amend the complaint and to to do that in accordance with your client's interests. So when you file, there are really two documents that you're going to be preparing. The first is the complaint for third-party custody. We have samples available to you in the training manual, and also your mentor can send you a sample if you need that. If there was a prior case to which the third party was not a party and they're seeking to modify or to get involved in that pre-existing case, the client would not be filing a complaint, they would be filing a motion to intervene and a motion to modify custody. So again, it's important to know the procedural posture. The other thing that needs to be filed with the complaint is a family court cross-reference form. And that's really a form that provides the court with information about the parties and about the child so that they know within the court if there are related cases. It's not part of the public record. You don't have to make great efforts to find the information that they're requesting. You kind of fill it out with what you know and provide it to the court. It used to be that we would submit a summons for each defendant, excuse me, when we were filing the case, but now those are being prepared by the filing clerk, so you'll be given that. In many cases, you'll want to file a third document along with your complaint and your cross-reference form, and that document would be an application to proceed in forma pauperis, or an application to have fees waived, which would waive all the filing fees in the case going forward. So a fee for filing an initial complaint in DC Superior Court is $80. Subsequent motions are $20 a piece, and that can provide a real hardship to clients. So you want to make sure that you talk with your client early on about whether they might be eligible for a fee waiver. Folks who receive public benefits like TANF, Medicaid, food stamps are presumptively eligible for a fee waiver. If they don't get those specific benefits, they may get other benefits which would render them eligible, or likely render them eligible even though it's discretionary, or you can provide some information about their assets and their income to the court that would demonstrate that paying those fees would be a substantial hardship. So if you are gonna file that application for a fee waiver, you're gonna send that application along at the same time that you send your complaint and your cross-reference form. So how to file in the era of COVID-19. This process has been really overhauled in the last few months by necessity. So it used to be that cases could only be initiated by going in person to the courthouse. For obvious reasons, we're not doing that now. So the new process is that you email your documents to the Family Court Central Intake Center at the email address that's on the screen. So if you're requesting a fee waiver, the Central Intake Center will process that application and the filing of the complaint at the same time and get it all back to you, give you a case number, let you know that it's been filed. If you're not requesting IFP status, then Central Intake will take your complaint and help walk you through the process of initiating the case through Case File Express, which is the e-filing system that DC Superior Court uses. At that time, when you file your case, the Central Intake Center will also issue a summons. The summons will not actually have an initial hearing date. So that's a change from before. What the opposing parties will get is a notice that the case has been filed, that a pleading has been filed, but they're not going to have a hearing date yet. We've included some practice pointers on the early stages of the case that I'm not going to focus on here just because we have such limited time together, but they may be helpful as a reference later or to look over as you're filing your complaint. So at the time that you file, the case will be assigned to the judge. If there was a pre-existing case and you're filing a motion to intervene and a motion to modify, the case will be assigned to the judge who was already on the case. It may or may not be the same judge the party saw before because in Superior Court judges rotate assignments. So if the case is a few years old, it's possible there could be a new judge, but it will be put on the same calendar. And as I said, the clerk will issue that summons, but not schedule a hearing date when you file your complaint. I will also say that in the past, before COVID-19, once a case was filed, the parties were required to attend an educational program that we kind of colloquially reference as a PAC seminar. It's not up and running right now, so I'm not going to spend time on it today, but information about it is included in these slides, and the materials are here for your reference. I don't know if litigants might be required to attend at a future date, so it's just something to monitor in your case or be aware of if your client says, I've been ordered to attend this. So we're going to turn now to service. So each defendant must be served, or each opposing party must be served with a summons and a copy of the complaint. That initial hearing notice, again, is not going to exist at this point in time. The third party who is seeking custody is responsible for ensuring service. So they have to ensure that there is an adult who is not a party to the case who can effect service on the opposing parties. Motions to intervene and motions to modify custody may need to be served like complaints under certain circumstances. Again, I won't spend time reading to you what is on the slide, but if these circumstances are at play in your case, you're going to need to look at Domestic Relations Rule 4 and serve the opposing parties in accordance with that rule. So there are several methods for serving a complaint under Rule 4. Most commonly, I think we see personal service. So that could be delivery, personal delivery as described on the slide. So delivering it directly to the defendant or leaving it with a person of suitable age and discretion at the defendant's home. Again, the server has to be somebody who is an adult, but who is not the plaintiff and not the lawyer on the case. The other way to effect personal service is by sending the summons and the complaint by certified mail with a return receipt requested. And that would again be signed by the defendant or a person of suitable age and discretion residing at that home. There are other methods of service also. So new as of 2018, when the domestic relations rules were revised, there's an option to serve parties by first-class mail with an acknowledgement that the opposing party has received that. If there's the new rules also provide for service by alternative means. And so what the rule says is that if the complainant is unable to accomplish service under Rule 4C2, so those are the methods that we just reviewed, after making diligent efforts to do so, then the court can authorize service by a means that is reasonably calculated to give actual notice. And the bullets below that line are specific examples that are given in the rules as what might constitute alternative service. I think most commonly, what we've seen in court is a judge permitting alternative service by text message or private message over social media, where they instruct the plaintiff to maybe take a photograph of each page of the complaint and the summons, and then to send those by text message or by private message to the defendant in the case. There is also a mechanism for constructive service. So if the defendant or the opposing party can't be found, the court can authorize service by publication or by posting. And I won't spend much time on constructive service today, but please feel free to contact Children's Law Center if you have questions or want to talk through whether to pursue constructive service in your case. And again, we probably have samples that we can provide you with, sample motions we can provide you with also. So service during COVID-19. Obviously, service might pose a particular hardship when we're all trying to maintain our distance from each other and people are reluctant to go out of their homes or allow other people into their homes, and the court has recognized this. So there was an order issued by the court on June 19th, and I'm going to read the language to you directly because I think it's important. So the court said that because individuals are likely unable to comply with social distancing and diligent efforts to serve, either personally or by going to the post office to obtain a certified mail, electronic service via text message or email is permissible in accordance with Rule 4C3B without further order of the court. The serving party must prove service to the satisfaction of the assigned judge, including showing that the electronic method of service was reasonably calculated to give actual notice. So I will say briefly that there are some exceptions that apply. They are not exceptions that commonly come up in our cases, but if you are affecting service by alternative means, I would encourage you to check out the order. It is linked in your materials here. But again, based on what I've seen from judges in the past, I think that if you or if your client has had recent communications with a defendant or with an opposing party by text message or by email, and you could show that you have reason to believe that they are actually checking this account, they're actually the account holders, and you can provide them with the summons and the complaint by those means, that probably would suffice as alternate service that is reasonably calculated to provide actual notice. I'm offering my opinion there. That's not dictated by the court that that is sufficient, but I would imagine that that's the kind of thing that the court is looking for when they issued this order. Once service has been affected, the moving party does need to file an affidavit of service. There's information about what that affidavit would look like depending on what the means of service was. The affidavit of alternative service probably would look different depending on what the method of alternative service is. So again, you can call your mentor and we're happy to strategize. I would imagine that if you can have somebody, again, who is neither the third party nor the lawyer on the case, so if you have a legal assistant or if the client has a friend or family member who can help, send the complaint and the summons to the opposing party by text message or by email, and then file an affidavit of that effort and give an explanation why you think that that method was reasonably calculated to provide actual notice to the party. I would think that that is the kind of thing that would belong in an affidavit of service, but we can talk with you further on a case-by-case basis, certainly. After effecting service, the opposing party has 21 days from the service date to file an answer to the complaint. And in that answer, they may admit the allegations in the complaint and consent to the relief requested, or they can deny the allegations and contest the relief requested. And often that comes with a counterclaim, or frankly, the court treats it as a counterclaim, because even if, party A does not get custody, somebody has to have custody of this child. So the court often treats a contested claim as a counterclaim in practice. So we've kind of made it through case initiation, and we're going to turn to those next steps now. So again, new for COVID-19, the court will set an initial hearing after and only after service has been affected. So what the court is looking for is a responsive pleading that has been filed, or the court is going to look for an affidavit of service that has been filed, and those 21 days for responding to the complaint have passed without a response. And the court is going to make sure that it's feasible given the status of court operations, because court hearings have moved remotely. And while they are adding capacity every month to hear more cases, they're not at the same capacity that they would have if we were all live and going about our normal routines. And then the court process after that really, again, is a case-specific determination. So that initial hearing is effectively a status hearing in the case, where parties will appear. The court is going to take stock of the procedural posture, perhaps have some questions about how the child is doing, what the history has been, and try and assess what the next steps in the case are. That may be the only status hearing in the case. More likely, it will be one of multiple status hearings that you will attend or that your client will attend over the life of the case. And so at those status hearings, each one you can be thinking about whether any requests need to be made, what advocacy you need to do with your client, whether you want to pursue some sort of negotiated resolution of the case or really push hard for trial. All of those are conversations to have with your client and to be preparing for in advance of those hearings. You can also think about whether you need to make requests of the court, either by filing a motion that will be right before the status hearing or addressing it orally at the status hearing. So for example, sometimes a party will file a motion for a home study, asking that a social service professional go out to one or more, to a home or homes of the parties to the case to do an assessment of safety. The court can also order custody evaluations like psychological evaluations of the parties, or an assessment of the interactions between each caregiver and the child. So you may think about whether that would be helpful in producing facts in your case and in advocating for your client. Know that the court could wish to appoint a guardian ad litem. A guardian ad litem in the District of Columbia is an attorney who is appointed to represent the best interests of the child in the case. And so that may be something that the court wants on a given case and could cause some delay, or be another avenue for advocating for your client. I will just drop a pin to say, if you or your client is thinking about whether to request a guardian ad litem for the child in the case, I'd encourage you to talk that through with your mentor, talk through the pros and cons, and we can help you assess in any given case whether that is a decision that makes sense for your client and for the case, or if there might be risks that you don't want to take on behalf of your client. A couple other things that are not mentioned specifically on the slide. So custody proceedings, family law proceedings in general, can have a tendency to feel a little bit loosey-goosey, particularly if you're used to other kinds of litigation. And you can kind of exploit that informality or invoke a greater degree of formality, as is going to be helpful to your client. So one example for that is, you'll see on the slide that there's a lot of questions about, should you request any sort of temporary order at this hearing? Do you want a temporary order that gives your client sole custody, for example? Does there need to be some sort of temporary order specifying visitation for one or more parties, or how communications will occur? Those are all things you can talk throughout the hearings. There is also in the third-party custody statute a section specific to pendente lite requests for custody that lays out very specific timelines that the court has to follow in having a hearing on pendente lite custody and holding a trial after that. And certainly you can file a formal motion for a pendente lite hearing and invoke those timelines and those requirements when you think that is going to help advance your client's goal. Another thing that I failed to mention, particularly in the coronavirus era, is that there is a process for emergency hearings if an emergency arises on your case. So emergencies are defined really, really narrowly by the court, because they generally are ex parte hearings where the court is not able to hear from all the parties, and the court dislikes having ex parte hearings about custody of a child. But if there is an emergency that comes up on your case and you don't think that it can wait the 2 months until you get before the court, or frankly even the 14 days that the rules say a responding party has to respond to a pleading, you can pursue an emergency motion, and that's something, again, that you could talk through with your mentor. Finally, I've talked a lot about consents, a lot about kind of how to advocate for your client and meet the legal standards at issue. You should know that there are free mediation services available in these cases through an office called Multi-Door Dispute Resolution Center, which is affiliated with the court. And you may see the court order parties to go to mediation, at least to do that intake. You may also wish to ask that the parties go to mediation. So that is a tool that is available to folks. Right now, we're hearing that they have a backlog of cases, so you may not get in right away, but it is something that you could consider if you think that it's going to be productive on your cases. So some practice pointers related to COVID-19. Court resources right now, as I mentioned, are pretty limited. There was a time where, for example, Multi-Door was not able to offer any remote services, so they have the backlog. The judges are still sharing some remote courtrooms. And even though they're getting more, that's been a process over the past few months. So what that means is that we are seeing some elongated timelines in these cases, and it's something to be aware of in terms of advocating for your client and also counseling your client. When hearings are being held, they're being held by WebEx. And so the court, if you have a hearing, should be sending you instructions of how to log on to participate in those. You want to make sure that you read those. You certainly want to counsel your clients about what to expect, both in terms of the instructions, but also in terms of what it feels like to have a web hearing. You know, maybe they've participated in Zoom meetings with their kids' teacher. Maybe they've never logged on before. But you want to give them some feel of who's going to be on the call. What is it going to look like? How are they going to share turns talking? How are you and they going to talk? How should you keep in touch if the client has questions, right? So if you go to court in person with your client and they're right next to you, you're able to kind of just give them a little nudge or say, you know, they can write a note to you if they have questions. We can't do that virtually, so it's a good idea to have a means for staying in communication. So for example, I have a hearing tomorrow where I told my clients, like, this is my cell phone number. I'm going to have my phone right in front of me. You text me if you are unsure about something or think I haven't addressed a point or have anything else that we should communicate about, or have trouble logging on, because that happens too. And then finally, I don't know why, but the WebEx platform has more audio feedback than I've heard on any other platform. So it's really important to keep yourself on mute, to counsel your clients about muting. The judges can get kind of testy when people are not muting or when people are talking over each other, and there's all of this feedback in these cases. If a party is served and no answer is filed, the third party can file a request for default. The way that that works under ordinary circumstances is that you file an affidavit in support of default and compliance with the Service Members Civil Relief Act. And there's information about the Service Members Civil Relief Act on the next slide in your materials. But you file that affidavit, the clerk should enter default on the docket, and then the judge would set a hearing in the case. Different judges, I've seen different judges handle defaults differently. I read the statute to say that even when a third party is proceeding in default against the parent, that third party still has the burden of rebutting the parental presumption. And so you should expect, and if the judge doesn't do it, then maybe ask to have a brief evidentiary hearing so that you can establish standing, so that you can rebut the parental presumption and demonstrate why it is in your client's best interest for your client to be awarded custody. I will say that, you know, I think that this is a moment to take pause in the COVID-19 era. We have heard anecdotally that judges are willing to proceed on defaults, but certainly there are different barriers than there are in ordinary times to filing answers, to appearing for hearings, or otherwise defending a case. So you really want to think on your case. In your particular case, if it's going to be advantageous to your client to proceed in default, or if there might be a reason to wait, you know, so that you can make sure that you do have a defendant's participation and have just really tight due process so that your client's order is that much more stable. If the case is contested and it does not settle, the court will hold a bench trial. Discovery and trials are governed by the domestic relations court rules and are very much like civil trials. I will say discovery in these cases is not, it's not, I won't say it's atypical, but it's not the norm either. Often these cases involve self-represented litigants who have limited resources to respond to discovery. So if you're thinking about serving discovery requests in your specific case, again, I'd encourage you to call your mentor and talk through it with them. We will talk more tomorrow for those of you who can join us about pretrial and trial advocacy. But once the trial has happened and the court is going to make a ruling, it must issue written findings of fact and should issue written conclusions of law as well. And then it's important to know that all custody awards are subject to modification. One other thing to note is that judges are encouraged by the court's operational order to issue written findings of fact and conclusions of law within 60 days of a trial. If you're experiencing significant delay, it's something to strategize about with your mentor. So I mentioned that custody cases are always modifiable. What is the standard for modification? And the answer is, it depends. So if the custody order was reached by revocable consent, then the parent would either file the motion to modify or file a notice of revocation, and the burden would be on the third party to maintain that custody arrangement or to advocate for what they think is in the child's best interest. They would have the burden to overcome that parental presumption by clear and convincing evidence and to demonstrate best interest by a preponderance of the evidence. By contrast, if the original custody order was reached by non-revocable consent and the parent has waived application of the parental presumption, then the burden is on the moving party, so whoever is seeking a change. And what that party needs to show is that there has been a substantial and material change in circumstances and that it is in the child's best interest to modify custody. So if the third party has custody and the parent is wanting a modification and they have provided non-revocable consent and waived application of the parental presumption, the burden is going to be on them to meet that standard by a preponderance of the evidence. And that same standard applies if there was a trial and the court made written findings that the parental presumption had been rebutted by clear and convincing evidence. One practice pointer I forgot to mention about trial is that if you do have a trial, you do want to offer to draft findings of fact and conclusions of law for the judge, because it's another advocacy opportunity to make sure that the court is proceeding under all applicable grounds, to make sure that you're producing a record that is as solid as possible for your client and that the order says what it is that you are hoping the judge will say. So we're going to wrap up by very briefly touching on caregiver resources. I'm not going to talk about them in detail, but if you represent a third-party caregiver, I encourage you to check out these slides and to talk about these resources with your client. They can be really helpful. So there is a grandparent caregivers program that provides a subsidy to eligible grandparents and great-grandparents taking care of children in DC. There is also a new, as of this year, close relative caregiver program, which also provides a cash subsidy to eligible caregivers who are taking care of relative children. New during the pandemic, the DHS now has a mobile app. So caregivers who are applying for TANF, SNAP, General Assistance for Children, Medicaid can apply by app. And then there is also a tool called a custodial power of attorney that allows a parent to delegate his or her parental rights without having to go through the process of court. So that's another tool to be aware of that might be helpful in your particular case. That is part one of our training today. It was a lot. So what's next? We'll be happy to see as many of you as we can tomorrow for part two of our training on pretrial and trial advocacy. If you can't join us, if you're watching this remotely, those will be up for streaming on our website as well. And we're happy to take any questions that you have. Let me just take a look at the chat.
Thanks, Lauren. You'll see I just popping in. I linked a survey for today's training. If you all don't mind clicking on that, we've got a quick survey. We'll send out a post-training email as well with it included there. But sure, if we have any questions, we've got about 5 minutes. We're happy to give your 5 minutes back. But also you can email me, just as Lauren said, and I just want to say thank you. We can give it a couple of minutes in case people have questions. Lauren, of course, thank you so much.
Yeah,
at this
stay on to the end of the hour, so people are taking time to write in their questions. I don't see anything coming in, but as Jen just put in the chat, we have cases available for these matters. She's happy to discuss them with you, to answer questions, help you find a good fit. That was my addition, not hers, but I know that she is happy to do that. Thank you so much for your interest in our training. Thank you so much for your time.
All right, thanks, Lauren. Thanks, everyone. Enjoy the rest of your day. Thanks for tuning in with us for part 1 of Caregiver Custody. This will be made available on demand if you want to check it out again or reference back to it. And then part 2 will focus on pretrial and trial advocacy. So we hope you'll join us either tomorrow or on demand for that follow-up. Thanks, and take care, everyone.